So we just got done talking about Patrick Doles in the last video, my co-defendant, and how he was under the impression that he had immunity. And so he said some things in trial that he later recanted before sentencing. Now, we're going to talk about the government's first witness, their expert witness. Remember the one that works at Bank of America? Let me walk you through and show you how the government not only knew their first two witnesses were lying, but they took steps to cover it up. Let me show you.
So let's go back to when Doles testified. He testified on the first day of witness testimony. He was the second witness. The first witness was this Kelly Bodecker, a senior credit risk officer with Bank of America.
And this is in appellate case 11-3463, filed 11/7/2012. Counsel who argued that her, Kelly Bodecker's testimony was more prejudicial than it was probative.
And Bank of America just was a victim in my case. So Bank of America has a stake in me being the guilty party, not them being the guilty party. And the government calls up this person as another expert witness, Kelly Bodecker, and she's going to set the stage for the government. So she's going to be their teaching witness. They believe this is complex enough that the jury should hear from an expert what's really going on here. So they bring this person in to
teach the jury. And Bodecker was to be the first government witness called to explain mortgage underwriting standards and the considerations material to a lender in the underwriting context.
Right? And so keep that in mind. Let's go back to the day of Doles' testimony. Who's first? Kelly Bodecker. Who's second? Patrick Doles. Patrick Doles is the government's star witness. Their star witness recanted that he was ever in a criminal conspiracy or ever had any intention to commit fraud. They had the teaching witness, and then they have Patrick Doles.
So hopefully that brought you up to speed to who we're talking about, right? So remember, witness one is a purported victim disguised as a disinterested third party, no less an expert, who was later paid $250,000 judgment after I was found guilty. And she's there to set the stage and validate witness number two, the government's star witness, who thinks he has immunity and later recants his trial testimony. And she's here to set the stage so that everything that Patrick Doles said fits nicely into place with what Kelly's saying, and the two create this appearance, right, of coherentness that is designed to mislead the jury with the first two witnesses of the case. So these are the trial transcripts, right? 10 CR 326, document 142, filed February 7th, 2012. This is from trial, May 17th, 2011. So Mr. McLaughlin says, with that, Your Honor, the United States calls Kelly Bodecker, the expert who really works for somebody who's going to get paid $250,000 if I'm found guilty. And she's here to set the stage so that... So she's sworn in.
Good morning, Mrs. Bodecker, and welcome to the state of Minnesota.
She says,
thank you.
There's a rumor floating around that you are a person who knows what lenders want to know. Is that true?
That is correct.
Question. To be clear about it, you are not a person or witness involved in this case, correct?
That's correct.
You were being called to essentially educate us about mortgage lending and underwriting. Is that true?
That's correct.
The court. Mrs. Bodecker, would you please pull that microphone a little bit closer to you? Thank you. Mr. McLaughlin.
Mrs. Bodecker, there's this term underwriting. It's always been a matter of some confusion to me. What is mortgage underwriting? What do mortgage underwriters do?
So if we go to the transcripts, there's an objection on page 12, line 19. Your Honor, lack of foundation. Go down again to page 13. There's another objection. Your Honor, leading the witness. The court.
Well, again, it's been leading all along.
Ferguson. Yeah. The court.
Mr. McLaughlin, I'm going to let you lead a little bit just to hurry things along, but let's see if we can't do it by question and answer. So I'm going to sustain the objection. Go ahead.
Let's fast forward. She's already testified. I've been sentenced. I'm in prison, and we're on our direct appeal. Let's look at that. So now this is on my direct appeal. This is the government's response to what my attorney raised about more prejudicial than probative. And I can't really fault my attorney for not raising the issue I'm going to show you about, because the government took steps to hide it. But here's what they say. I just want to, because everything with them is well founded by the record. If we go down to page 35, which is really, I think, 25 on their document. This is document ID 3902941 in the 8th Circuit Court of Appeals, case 11-3463. It says, at trial, defendant did not object to the admission of Ms. Bodecker's testimony. Defense counsel only objected to certain exhibits being shown to her. This is insufficient to preserve the issue which he raised. Skip down. I just kind of briefly scan with me. Tell me if you see any exhibits being entered into the case at all. Okay, so we're now on page 10 of 248. We're still testifying. And on page 10, I'll just kind of draw your eyes to this. She's given some idea about like what realtors do, what processors do. Get down to the bottom of page 12. Because see, when you get to the bottom of page 12, right? Mr. Ferguson, objection, Your Honor, lack of foundation. And okay, so let's just scan back up. And there's, something like 58 pages of testimony on this before we even get to an exhibit. Now, they had a 1003 example, but there was no objection to that exhibit, right? And let's walk through it. Okay, so here they are, page 58. With this in mind, Bodecker, I'd like to now show you some of the documents from the actual case, right? We're all the way on page 58. There's been 58 pages of testimony. There's already been 2 objections, right? Relevance and leading the witness. And the court made it clear he was going to allow this to go on. So I'm going to say bullshit. Objection was made. Objection was preserved. Let's see what the appellate court said about it, if they said anything at all. So now this is my direct appeal. Remember when I got thrown in the hole, my evidence and pleadings got confiscated, destroyed, and I didn't get to file to the Supreme Court, and they wouldn't let me fire my attorney, and they didn't listen to any of my issues. So that appeal. Now we're going to go down here to Part B, page 5, and this is in appellate case 11-3463, filed 11-7-2012. So this is the United States Court of Appeals. This is the decision, right, where they deny my appeal. And my counsel who wrote this, or wrote my argument, argued that Kelly Bodecker's testimony was more prejudicial than it was probative. Or we're on page 5. Spencer next alleges errors in the admission of Bodecker's expert testimony. He first complains that probative value of Bodecker's testimony was substantially outweighed by danger of unfair prejudice, and that the court should have excluded the testimony based on Federal Rule of Evidence 403. Spencer raised no such objection in the district court, and there was no plain error in admitting the testimony. So they're saying we didn't object to this. And see, that's another way that they'll cheat you or your loved ones out of your appeal, right? They'll reduce your stuff to real high standards of review that you can never win on. They'll outright lie, right? They said that we didn't object to anything until we objected to some specific exhibits. And why would they lie and say that when that's not the truth, right? I just told you 58 pages before a single exhibit was introduced, and there were 2 objections made right at the very beginning before anything like that was introduced. So an all-out lie. Ask yourself, what would be the need to do that, right? From these well-grounded in the record responses that the government claims that it makes. So these are the trial transcripts, right? 10 CR 326, document 142, filed February 7th, 2012. This is from trial, May 17th, 2011. I'm looking in here, and I don't see any exhibits. That is the only thing supposedly, and you heard what the government said in their thing, that, you know, that's the only thing we objected to was some exhibits. There hasn't been any exhibits yet, and we're down to page 12. We got our first objection, and we're going to keep going down. Oh, there's another objection. Look at this. This is page 13. Mr. Bergeson, objection, Your Honor, leading the witness. And you guys can pull this off, Doc 142, read it. Now she's giving her opinions about what an appraiser does, right? So that's what she's saying, right? So she's going through their theory. She's basically telling the jury what everybody does, what everybody's supposed to do, all above board, you know, as if all these participants in this chain are above board. They're saying that she responded to a hypothetical question, right? So remember, witness 1 is a purported victim disguised as a disinterested third party, no less an expert, who was later paid $250,000 judgment after I was found guilty. And she's there to set the stage and validate witness number 2, the government's star witness, right? My co-defendant, Patrick Doles, the one who thinks he has immunity and then later recants his testimony. So do you wonder why they've got a 99% conviction win rate? This is why. The expert who really works for somebody who's going to get paid $250,000 if I'm found guilty. Right? This is why, right? Every part of the process is corrupt. Now, this is document 149. It was filed on February 24th, 2012. And this is Adam Christensen's testimony from May 18th. And if you go to line 16, 3N is mentioned on line 16. This is one of the first times that 3N was mentioned. But I went through and I tracked them all down, right, to see if we were going to have any transparency at all about Bank of America. Right. So now I'm trying to argue this, right? This is filed on June 7th, 2012. And I actually filed something just like this earlier, never made it on the docket. Maybe it's the locked docket, but this is 11-3463 in the 8th Circuit, entry ID 3919754. And I say that the prosecutor is kind of vouching for witnesses, like with Kelly Bodecker. He told the jury in his opening that she was going to set the stage, right, for the case. And I talk about this here. I say, but I had raised this all the way back in 2012. In fact, in regards to tainted testimony, of all the mortgage and lending experts available, the prosecutor called one who happened to be from a bank that the defendant had allegedly defrauded a victim as an expert at trial seems rather inappropriate, dubious, and the testimony tainted. Testimony from a victim being described to the jury as an expert seems prejudicial indeed. So remember, witness 1 is a purported victim disguised as a disinterested third party, no less an expert, who was later paid $250,000 judgment after I was found guilty. And she's there to set the stage and validate witness number 2, the government's star witness. But these are the slippery slopes the prosecution willfully embarked on. If the evidence was so overwhelming, the risk of such a controversy seems hardly rational or necessary, especially when considering the vast resources of the prosecution. Now, keep in mind, I'm going to show you the judgment that existed at this time. Bank of America is not listed on it. MERS isn't even listed on it, right? So let's go back into my criminal docket. Case 10CR00326. We go down to May 17th, right here. This is where Kelly Bodecker and Doles testify. We go down to October 31st. And this is what I'm sentenced. This is the judgment that I'm going to show you now that was in effect when I wrote that to the appellate court back in 2012. So what they have publicly filed at this time, Doc 109, filed 10/31/11, is a 6-page document. We'll scroll through it and tell me if you notice anything different from the next document we're going to see after I show you where that comes in the docket, right? So this is 6 pages. And this is when I'm getting snatched up, thrown in the hole, silenced by my defense counsel, not getting any of the transcripts, not anything. I get to the new spot after I'm transferred. A foot of my legal evidence, legal work is gone. But I had raised this all the way back in 2012 because I had gotten word that Kelly Bodecker and Bank of America lied to the jury at my trial. So this is the direct appeal right here, 113463, 8th Circuit Court of Appeals. And we go down to June 7th. That's when I raised the issue of Bodecker right here. And they decided it. My petition for rehearing in bank was denied on 12/13/2012. So my ability to file in the Supreme Court would have been January, February, March. So about March 13th, 2012. That's when the Supreme Court time deadline would have passed. And the last stuff going on in this case, 3/8/2013. And the last entry in this case is March 8th, 2013. So keep that date in mind, right? My case gets its final on December 13th, 2012. And then by March 13th, 2012, the Supreme Court time will have expired. Now remember, before that, all we have is this 6-page document filed on 10/31/11. That's all we have through that whole appellate process. All right. So now let's go look back at the criminal docket and see if anything at all is going on. Again, same case, criminal docket. So we're going to go down. Remember, the appeal was finalized December of 12. Supreme Court timeline would have ended March of 13. And March of 13 is where we also see the last docket activity in the appeal. So we'll go back and we'll go to the beginning of 2013, see what's going on in the case. And we come down to May of 2013. What do we have? We have an amended statement of reasons, document 194. We've got an amended sentencing judgment, right? So they waited. So a couple months after the Supreme Court deadline passes, but not before, on May 20th, they do an amended sentencing judgment, a bunch of different amended sentencing things. Let's take a look at what those things look like, right? Now, this is before my 2255. Do you see it? Right before my 2255 is down here in December, and right before I file my 2255 in May, right after the Supreme Court time in my direct appeal expired, they go in and they change the judgment document. Let me show it to you. So here's the document that they filed in May, 5/2013, doc 193. And you see this? There's 2 extra pages now. The other one had 6. We've got 2. Let's see what's on those extra 2. We've got 5/2013. We've got a list of banks now, a list of victims. You see no grandparents, no people in their savings, all well-informed lending institutions. We get down to the end. And look at this, the very last one, MERS, 253-100, MERS on 5/2013, right after the Supreme Court deadline passed, right before I'm going to file my 2255, and after I talked about Bank of America in my direct appeal submissions that were ignored. How would anybody link MERS, which looks like it's purposely disguised now to, conceal that it's really Bank of America, it's really Kelly Bodecker? How would anybody link that and know that at this point when it's actively being disguised, right? First, it wasn't on there. Now, all of a sudden, there's this entry on there, MERS, right? No one knows what that is. No one can link that to Bank of America or Unit 3N. And the jury can't evaluate the motives or how this witness sits in relative context to the situation as a whole because that's being concealed from them. She's basically being presented as a disinterested party in this case. Yet she stands, if Spencer's guilty, to get a $250,000 judgment for her company, Bank of America, which before now was mentioned very little and is now disguised and memorialized into the record here as MERS. And so that stayed on the record, right, all the way down here till I'm filing my 2255 and document 197, right? Pro se motion to vacate. Okay, so no doubt that I raised that issue in my direct appeal, but they just ignored me, right? Then threw me in the hole and got rid of all my evidence. And now we're in 2013, December 17th, 2013. And this is Doc 197-1. This is my 2255. This is what I say in my 2255. The prosecution's teaching witness, a 702 expert, was in fact employed at the time of trial by an alleged victim of the conspiracy, Bank of America. Remember, I'm asking for transcripts too, and they're denying. They say I don't need them. I don't need any discovery. The jury should have been informed of this in an instruction. Further, since then, Bank of America has settled for its fraudulent conduct occurring in and around the same time of my alleged conduct. A reasonable fact finder could consider that banks like the one here have proactive interest in providing teaching witnesses who would establish blame on low-level participants, guilty or not, to exculpate themselves, gain leniency through cooperation, and take public heat or draw attention away from the real reason for the market bubble and collapse themselves. Not the allegedly material omissions at the origination level, but fraud at product development, advertising, and willful blindness on their part, detectable corruption, and that banks didn't implement deflection plans is just unfathomable. And having an employee of an alleged victim is highly and unfairly prejudicial, right? So that's what I'm raising now on December 17th, 2013 in my 2255 after trying to raise it in my direct appeal and being ignored. And so sometime between my direct appeal and now, can we agree that the government realized that I'm raising this issue and I know about it. Can we agree on that? So this is the government's response to my 2255. It's Doc 215 in my criminal case 10 CR 00326 DSD, page 58, filed on May 30th, 2014. May 30th, 2014. Keep these dates in mind now, right? And we're going to go down now to Spencer argues that defense counsel should have requested a jury instruction to inform the jury that Bodecker, the government's teaching witness, was employed at the time of trial by Bank of America, an alleged victim of the conspiracy. He does not explain how this error deprived him of a fair trial. That's what they say. Spencer has previously alleged error in admitting Bodecker's expert testimony on direct appeal.
But they're talking about the argument my attorney raised, not the arguments I raised, which they ignored. And then, of course, my attorney didn't have any notice that Bank of America was connected to 332 Fisk Street, Unit 3N. There was no link made yet, no disclosure, right? In fact, Kelly said that she was a disinterested third party. And then on top of that, at the time, just up until like a couple months before my 2255, the victims weren't even listed. And then when they finally were listed shortly before my 2255, then of course they had that mysterious MERS on there to disguise Bank of America.
The Eighth Circuit held there was no plain error. Now, we already talked about that. They lied and said that, we didn't object. All we objected to were some exhibits, right? But we get 58 pages in, no exhibits. We already got 2 objections. Even if Spencer's argument isn't procedurally barred, his claim is undermined by the record that say, again, the government elicited testimony from Bodecker that the jury, she was a current high-level employee of Bank of America. Defense counsel listed testimony from her that she testified only in mortgage fraud trials that involved Bank of America, and further that Bank of America had a lot of bad mortgage loans on their books. Finally, this court instructed the jury to determine the importance or the weight that witnesses' testimonies deserve. This court further urged the jury to assess the believability of each witness by carefully scrutinizing all the testimony given, the circumstances under which each witness has testified in every matter. So the court gave this instruction where they need to scrutinize all the testimony, circumstances under which each witness testifies, take every matter in evidence which tends to show whether witness, in your opinion, is worthy of belief, consider each witness's intelligence, motive to falsify, state of mind. And so here's the thing though, motive to falsify. If they can't link Bank of America to deals actually involved in this case specifically, and what is it, 3N, and the $250,000 that they're going to get if I'm guilty, right? Their specific involvement in this case. Now let's go back to the trial transcripts and just see what they actually say. Okay, let's go back to Bodecker's testimony, and this is Doc 142, and this is the testimony that the government wants you to recognize. And the question is, Mrs. Bodecker, you work at home for Bank of America. She says, that's correct. And do you testify for the Bank of America? She says, I have testified at a couple trials, correct. Question, have you testified in mortgage fraud trials? Answer, yes. Question, have you testified in mortgage fraud trials that didn't involve Bank of America? She says no. Okay, so let's cut right there. Does that mean that this also is a trial that necessarily involves Bank of America? I guess maybe it could mean that, but it could also mean that those are just the other few trials that she's testified at. He says, when was the last time you testified? Which lends further credence to past tense thinking. So when was the last time you testified? She says last week. Where did you testify? She says in Michigan. Now he says, did you get paid? Is that part of your duties, or do you get paid extra to testify? She said, I do not get paid extra. When they ask for representation, I've been able, with my background, to fulfill those requirements just in my standard job. That's the testimony that the government wants you to recognize. Let's go back to page 5. And you tell me how that jives with what they say here. Doc 142, page 5. To be clear about it, you were not a person or a witness involved in this case, correct? That's correct. So they want you to fine for them on their semantic games argument, right? Oh, she just said her personally, right? They don't want you to accept the fact that she just told the jury that her testimony is completely disinterested. It has no interest in this at all. I'm a disinterested third-party expert. And although I testify for the government and it's always involved Bank of America, I'm not a party to this case. That's what she said. You tell me if that's not what was said here. Okay, so here's what the judge says, right? In my 2255, this is Doc 223, filed 7/21/14, and it's the jury instruction thing. It's where this is where he talks about it at number 4. Finally, Spencer argues that he received ineffective assistance of trial counsel because trial counsel failed to object to the court's inadvertent failure to deliver a limiting instruction on the expert testimony of Kelly Bodecker, given her professional affiliation with victim Bank of America, and 2, failed to request a limiting instruction on the admission of summary charge prepared by the government. Even if Spencer could demonstrate that failure to object to the admitting instruction or to request a limiting instruction on the charge was professionally deficient, however, he again cannot show that either would have created a reasonable probability of a different outcome at trial. First, as to the omitted instruction on Bodecker, the Eighth Circuit observed that the court's omission of the instruction did not constitute plain error. Further, the trial court instructed the jury to evaluate the believability of all witnesses, specifically emphasizing that the jury should consider each witness's motive to falsify and how the witnesses might be affected by the verdict. Now, see, isn't that very important? Because the jury didn't know that Bank of America was involved with, what was it? It was 3N. They didn't know that if I was guilty, they were going to get a judgment for $250,000, right? So they're not able to really evaluate the believability and know what the real motive is and how the verdict might affect them because that's being hidden from everyone. It was still being hidden from everyone. Let me show you. Let's go to the docket. Before I file my 2255 in May, right after the Supreme Court time in my direct appeal expired, they go in and they change the judgment document. Let me show it to you. So here's the document that they filed in May, 5/2013, Doc 193. And you see this, there's 2 extra pages now. The other one had 6, we've got 2. Let's see what's on those extra 2 institutions. We get down to the end. And look at this, the very last one, MERS, 253-100, MERS. On 5/2013, right after the Supreme Court deadline passed, right before I'm going to file my 2255, and after I talked about Bank of America in my direct appeal submissions that were ignored. How would anybody link MERS, which looks like it's purposely disguised now to, conceal that it's really Bank of America, it's really Kelly Bodecker? How would anybody link that and know that at this point when it's actively being disguised, right? First it wasn't on there. Now all of a sudden there's this entry on there, MERS, right? No one knows what that is. No one can link that to Bank of America or Unit 3N. And the jury can't evaluate the motives or how this witness sits in relative context to the situation as a whole because that's being concealed from them. She's basically being presented as a disinterested party in this case. Yet she stands, if Spencer's guilty, to get a $250,000 judgment for her company, Bank of America, which before now was mentioned very little and is now disguised and memorialized into the record here as MERS. And so that stayed on the record, right, all the way down here till I'm filing my 2255 and document 197, right? Pro se motion to vacate. We go all the way down here to the order denying motion to vacate 721, which I showed you. And then we have to go down a little bit because I tried to appeal it, even though he didn't give me a certificate of appealability. But we finally see that the Supreme Court denies this on right here in Doc 239, 39216, 39216. And so now they get a letter by USA as to John Spencer, right? And that's 240, that's on 9/16. And then we got Doc 241, order to correct the payee name from MERS to Bank of America as restitution payee. So my Supreme Court is over with. My last, court action, formal court action, this is typically where litigation stops for any criminal defendant. So at this point, you, your mom, anyone who's going through this, they're done. And you've seen the quality of adjudication that is involved in these things. But 6 months after the Supreme Court denies, they go ahead and they change it now to Bank of America from MERS, right? And just go all the way back from, the 2255 to the direct appeal to the trial where Kelly Bodecker is there. She tells the jury she's essentially a disinterested third party and she's an expert. She's there to set up the testimony for Patrick Doles, who's going to come in and cross all the T's, dot all the I's, right? The one who thought he had immunity and has, since recanted his statement. So on May 20th, 2013, restitution, remember, 253-100 was order payable to MERS, right? And before that, there was no list whatsoever at all, right? This is September 16th, 2016. And 253,100, John Spencer, same case, 10326 DSD. In this case, the servicer of the loan or lender was Bank of America, The servicer of the loan or the lender was Bank of America. And they provided the government with declaration of victim financial loss. They probably, in that 3 months from the time my 2255 Supreme Court action was denied until now, 3 months later, I'm sure Bank of America, provided that letter.
Like, hey man, this is final now. We can come out the closet, right? We don't have to hide this anymore because it's final. He's done. He's toast. He can't do nothing about it now. Ha ha.
Remember what I said? They lie awake and they try to think of ways to incriminate people. And so when he's putting this plan together, he never thought, oh man, he's going to discover this. Then when I did, right, I raised it on direct appeal before I went to the hole and my evidence was seized. Then I tried to raise it on the 2255, right? And you see when I did that, right, when I raised that on direct appeal, they changed it, right? They came out with all those victims. They put MERS on that. Then I raised it again, right? Even more crucial. And they denied me, right? Wrongly, you might add. And after the Supreme Court time ended, what they do? They changed it again, right? Like, check this out. Here's the Supreme Court, right here, 239 on 3/9/2016. And here's where they change it, 9/19/2016. What's the reason for all that, right? If it's all kosher. Think about it. Now let's just go back up to what she says.
Good morning, Mrs. Bodecker, and welcome to the state of Minnesota. Thank you. There's a rumor floating around that you're a person who knows what lenders want to know, right? And to be clear about it, you are not a person or witness involved in this case.
That's correct. What's this right here? MERS. That's weird. What is that? Look at what's going on here. On May 20th, 2013, restitution of $253,100, more than $250,000, was ordered payable to MERS for loans associated with the property located at 332 Fisk Street. In this case, the servicer of the loan or lender was Bank of America. Bank of America has provided the government with a declaration of victim financial loss. And this was submitted by Andrew Luger. They didn't want David McLaughlin to submit this, right? They do this. They split this up on purpose so they can claim that they didn't know some of this. But why disguise this, guys? Because, again, this didn't change hands. right? Once this, came to fruition, either they would have known Bank of America was there on the front end, or by the time trial had started, they would have known Bank of America was there. This was done to disguise and hide this so that we didn't know what was going on. We couldn't really raise the real issues. Now, imagine if we could have asked Bodecker, Bodecker, so since you did 332 Fifth Street, then that Bank of America, who you train everybody, they charged the borrower an appraisal review fee, meaning that you had your own people review the appraisal and you came back with it and it was good. If these things are clearly fraud, how could that happen? And, isn't it true that people at Bank of America know this stuff is going on and like in 332 Fifth Street and they do it anyway? None of those things could really be presented or put into context because, again, they hid this, right? And if they didn't need to hide it, why did they? Why did they, right? My co-defendant, Patrick Dole's the one who thinks he has immunity when he's about to testify coming up next.
I submit to you that was clear fraud on the court, and they obtained a fraudulent conviction, violated my due process rights. And this conviction should be vacated immediately.